At BLM, we are keen to make sure you understand what's involved if you are referred to an IOT, and we are here to answer any questions you may have. Please watch the video which follows to find out more. We also provide further material for you to download, and details will follow at the end of the video. If you have any questions, please do not hesitate to get in touch. Please watch our other videos in the What If series for further information on legal know-how for clinicians.
What is the IOT?
The Interim Orders Tribunal, which is known as the IOT, is a tribunal run by the Medical Practitioners Tribunal Service, who are the independent adjudicator of cases referred by the GMC. The IOT's remit is to determine whether interim restrictions should be placed on a doctor's registration, pending the outcome of the GMC's substantive investigation. Doctors can be referred to the IOT at any stage of a GMC investigation into their fitness to practice. Cases are commonly considered by the IOT at the outset of a GMC investigation, shortly after receipt of the initial complaint, or when the GMC obtains information later in their investigation which indicates that it may be necessary to restrict that doctor's registration. The interim orders process is therefore separate but runs in parallel to the GMC's substantive investigation into a doctor. Consequently, any interim restriction imposed by an IOT in the early stages of an investigation will end when a final decision is made about the concerns. Many GMC fitness to practice investigations do not involve a referral to the IOT, and doctors in those cases can continue to practice unrestricted throughout the investigative process.
What types of cases are referred to the IOT?
Cases are referred to the IOT where the evidence suggests that it may be necessary to restrict that doctor's registration for one of the following reasons: protection of members of the public, where it's in the public interest to do so, and finally, where it's in the doctor's own interests. The protection of the public is a very broad category of cases, but routinely arises in clinical complaints or allegations of serious misconduct or criminal acts. For example, allegations that suggest the doctor's language skills or clinical knowledge is deficient and therefore puts patients at risk. Additionally, allegations that a doctor's behaviour has fallen seriously below the standards required by good medical practice would be relevant. In these cases, the IOT is concerned with protecting patients and other members of the public from the risk of repeating the alleged act. The public interest includes the preservation of confidence in the medical profession and the maintenance of good standards of conduct and performance. This often overlaps with public protection. The public interest is relevant at the interim orders stage of a doctor's case because the underlying allegations made against that doctor remain private and are not published. Accordingly, the IOT must consider whether it would be damaging to the public's trust in the profession if the allegations were later found proved and the doctor had been allowed to work unrestricted whilst the substantive investigation was ongoing. It routinely arises in cases involving alleged sexual conduct towards a patient or where the doctor faces serious criminal allegations such as manslaughter, rape, blackmail, sexual assault, and offences involving children. In those cases, the IOT can restrict a doctor's practice, even where the allegation does not relate to his clinical practice. In cases involving the health of a doctor, or serious lack of insight into the concerns raised, the IOT may consider it appropriate to make an interim order in the doctor's own interests. This would include cases of drug and alcohol addiction, depression, and other serious medical conditions that interfere with a doctor's ability to practice safely.
What information is available to the IOT?
In advance of an IOT hearing, the doctor and his legal representatives receive a paginated and indexed copy of the hearing papers. This is produced by the GMC and will include documentation regarding the underlying allegation and any other documents which indicate that an interim order is necessary. The doctor is also entitled to submit documentation to the IOT, either in advance of the hearing or indeed at the hearing itself. This might include testimonial letters from colleagues and patients, or evidence of CPD courses that the doctor has undertaken, which are relevant to the issues raised in these allegations. The IOT does not routinely hear oral evidence from witnesses, including the doctor. Instead, it makes a decision on the basis of the written material and any oral submissions made by the GMC and the doctor or the doctor's legal representative.
What test does the IOT apply?
The IOT effectively carries out a risk assessment, considering whether it's necessary to restrict a doctor's registration whilst the GMC's investigation is ongoing. It doesn't make any findings of fact, and it will not decide whether a particular allegation against a doctor is true or not. Instead, it assesses the seriousness of the allegation, the evidence before it, and the weight that should be attributed to that evidence when deciding whether an interim order is necessary. The test for the IOT is whether they consider that there may be impairment of the doctor's fitness to practice, which poses a real risk to members of the public or may adversely affect the public interest or the interests of the practitioner himself. If such a risk is identified, an order will only be made where it's necessary to guard against that risk. The test requires the IOT to consider the proportionality of any restriction on the doctor's registration, given the significant consequences on the doctor's ability to practice and his professional reputation. For that reason, the IOT is required to impose the least restrictive order to guard against the perceived risk.
What orders can the IOT make?
Having considered all of the evidence and any submissions by the parties, the IOT can make one of three decisions: no order, conditions, or suspension. In the case of no order, the IOT can determine that it's not necessary to make an order restricting the doctor's registration whilst the GMC investigation continues. Alternatively, they can impose conditions on the doctor's registration for a maximum period of 18 months. The GMC publish on their website a list of the conditions routinely imposed at IOT hearings, known as the Conditions Bank, and doctors can therefore review the conditions in advance of their hearing to understand the sort of conditions that might be considered. In the most serious cases, the IOT can suspend the doctor's registration for a maximum period of 18 months.
What happens at an IOT hearing?
Although the doctor is not obliged to attend an IOT hearing, urgent advice should be sought from a medical defence organisation or specialist lawyer before deciding not to attend. Doctors are routinely represented by a solicitor or a barrister at the IOT hearings and will normally have spoken to their legal team in advance of the hearing to discuss the procedure and provide instructions in relation to the substantive complaint. On the day of the hearing itself, the doctor and his legal team will attend the Medical Practitioners Tribunal service, which is located in central Manchester. Interim orders hearings are normally held in private, so members of the public and the press are excluded from the hearing room. The hearing room is relatively informal. It doesn't resemble a courtroom. The three tribunal members sit at one end of the room, together with a secretary, as well as a shorthand writer who takes a transcript of the proceedings. There are separate tables for the doctor and his representative, and the GMC's legal representative. The tribunal usually consists of 3 members, one of whom will be medically qualified. That medical member is not normally selected from the same speciality as the doctor involved. A list of all tribunal members is available on the GMC website, and details of the tribunal members will be confirmed in advance of the hearing itself. At the outset of the hearing, the tribunal chair will introduce the other members of the tribunal and ensure that the parties have received the hearing bundle. The doctor is asked to confirm his name and GMC registration number. The GMC's legal representative then presents the GMC's case. This involves an explanation of the background to the complaint and why the GMC say that an interim order is necessary. The doctor or his representative then has an opportunity to make representations in response and to present documents in support of the doctor's submissions. The tribunal members may ask questions of either side's representatives, following which the legal assessor or the legally qualified chair of the tribunal provides legal advice to the tribunal members. The tribunal will then adjourn in order to deliberate in private, and the parties will leave the hearing room. The tribunal will produce a written determination, and it can often take a couple of hours to receive that decision. Once the decision has been drafted, all parties return to the hearing room and the decision is read out. The MPTS website and the electronic medical register on the GMC's website will record details of any conditions or the length of a suspension.
What do I do if I'm referred to an Interim Orders Tribunal hearing?
The GMC writes to all doctors that have been referred to the Interim Orders Tribunal, and immediately upon receipt of the GMC's letter, doctors should notify their medical defence organisation or insurance provider and obtain advice about the next steps. It's likely that solicitors will be instructed on the doctor's behalf, and meetings will need to be arranged at fairly short notice.
What are the potential implications of an interim order?
The implications of an interim order will vary depending upon whether the order is one of conditions or suspension. All interim orders are recorded on the medical register, which is available to members of the public online. The imposition of an interim order also triggers a statutory requirement for the GMC to notify all EU medical regulators of the restrictions placed on that doctor's registration within 3 days of the decision. If the doctor is given conditions on his registration, then it's crucial that he complies with those. The requirements are mandatory and the deadlines are important. A failure to do so may lead to the GMC recalling the doctor to the IOT for consideration of an order of suspension. Interim conditions can also adversely affect private admitting rights, and it's important to review the contractual arrangements with your private healthcare provider in order to understand whether you're entitled to continue to provide private medical services under your GMC conditions. If the doctor is suspended from the register, he must cease clinical practice immediately. For primary care practitioners, the imposition of an interim order may lead to NHS England taking action against the doctor's inclusion on the performers list. In the case of hospital doctors, the Trust may take action to restrict clinical duties. Separate advice on this can be obtained from your medical defence organisation or solicitor.
We hope you found our video informative. To download further material, please visit the link on the screen now or contact a member of the team. Thank you.